Good morning.
Good morning.
Hey, it looks like my name was changed to Tillett, but those are different people. I'm just Yvette LaSalle.
Yes, sorry. I'm trying to quickly change names as fast as possible so we can stay organized, and I probably just cut and pasted wrong. Thanks for letting me know.
No worries, thanks.
So probably take the most time here is just checking everyone in. I'm going to get the service list on the screen. There's people joining us that I don't recognize anymore. Maybe they haven't participated in the written process. And let's share that list with everyone. So Max Lens, who's that person affiliated with? Can anyone help me with that? I think it might have
Good,
been,
good morning, Your Honor. Mr. Lenz is an attorney representing Whitewater Solar.
okay. So, since you guys obviously you'll be participating in many cases, if you wouldn't mind, to the extent you can, just try to get your screen name correct before when you log in. I haven't asked people to do that, but this case is just overwhelming. So I just put a WS for Whitewater Solar, and then a dash, and then the name of the person. Same thing with renew. I'm going to add in renew. People who frequently join us. How about Becky Fredericks? Anyone know Becky Fredericks?
Yes, Your Honor. Becky is, I believe she's standing in for Jared Colwalter.
Standing in and what?
I think she's his significant other. It's
Okay.
perhaps he can't make it to the meeting and perhaps she's there.
All right,
Or maybe they're together on her phone.
okay, we'll ask her then. All right, looks like not seeing many people left coming
I am
in.
here right now.
I'm sorry, was someone speaking?
Yeah, this is Jared Colton. I'm here right now and just seeing Becky's sitting in for me. We're moving cattle right now, so it's not the easiest thing for me to be in.
So are you speaking under Becky Fredericks's login? Is that what's happening right now?
Yes, and this is Jared Colton. I wanted to let you know that she's going to be in the middle of moving cattle. And I can't get out of it.
Oh, I guess I couldn't quite hear what you just said.
Yes, Becky Fredericks is going to be in for me.
Okay, so Becky will be participating on your behalf right now, and
Yes.
you're here, but you'll be leaving. Is that?
Yes, I'm moving cattle right now, just in the middle
Oh,
of.
okay. All right. I got it. Okay, so All right, and who logged in as iPhone? The iPhone is your screen name. Can you turn on your camera and let me know who you're affiliated with? Yeah, that's you. Your mic's going. Who is iPhone? May not find out until we go through the service list.
Your Honor, I think that was Mr. Colwelter. I think we just heard a cow. So I think that's who the iPhone is.
Okay, I think he
I just
turned
wanted to
off. All right,
clarify.
yeah, I wasn't sure who was speaking when that was going on. All right, so we have a phone number ending in 906. I'm going to ask you to unmute by pressing *6, and then let me know who you are.
Alan Wood,
Okay.
intervener.
Yep, thanks for joining us. There's no way to connect by computer, is there for you right now?
No, I'm traveling right now.
Okay, all right, no problem. All right, like we have no one else joining us, so that might be our balance of participants at this point. All right, so we are live streaming too, so people can observe. Might not be able to connect. Otherwise, we're good to go. So with no further ado, let's get started. Yeah, welcome everyone. This is a status conference. Let's get on the record. A status conference just before our party hearing session. This is docket 9828 CE 100. The application for a CPCN by Whitewater Solar. This is Michael Newmark, the Administrative Law Judge for the PSC. And let's do appearances on the record. We go through our list. We have everyone identified, so I'm not going to go through the entire list. Just try to catch everyone here. Not giving me this alphabetically either. So I think we can start off with Clean, Wisconsin.
Katie Nicola for Clean, Wisconsin.
All right. I think LaSalle is next. Oh, Colwelter. Who's representing Colwelter today? So you'll need to unmute and turn on your camera if you can. Let's go off the record. So I see Becky Fredericks. Are you representing Jared
Yes, this
today?
is Becky Fredericks. I'm here representing
Okay,
Jared
perfect.
Colwelter.
So let's just get on the record and just ask again for the record. So for Colwelter, who's representing Jared Colwelter today?
Myself, Rebecca Fredericks, representing Jared Colwelter.
Okay, great, thanks. LaSalle, who's representing LaSalle?
Good morning, Judge. It's Yvette LaSalle.
Okay, and Renew.
Good morning, Your Honor. Sharif Halawish for Renew, Wisconsin.
Okay, the PSC.
Good morning, Your Honor. Kara Kuntz for the Public Service Commission, and I'm also here with my colleague Sophia Rogers for the Public Service Commission.
Okay, great. The Tillets.
Good morning, Your Honor. My name is Ann Tillett, intervener.
Okay, and is Wade Tillett connected as well?
Yes, he's on a separate call.
I'm here as well. I'm having a hard time figuring out how to turn on my camera though. Sorry.
All right, not a problem. Okay, and Whitewater Solar.
Good morning, Your Honor. Brian Cahill, Max Lenz, and Mark Bender appear on behalf of Whitewater Solar.
All right, and Wood, Alan Wood. And if you heard me, Alan, just asking you to identify yourself for the record.
Oh, yes. Yes, Alan Wood.
Okay, great, thanks. So let's, did I miss anybody? Oh, yeah, I think we got everyone. Okay, so that's people appearing for this pre-hearing, sorry, not pre-hearing, status conference. All right, so it may help to continue to share the screen, because I do have sort of an agenda here. I tried to give you a little bit of a heads up what we were doing here today, but for cases with this many people, and we're going to be meeting in person this week, it's good to just get to touch base and get some logistics, get some things out of the way in terms of motions and legal decisions, and also touch base about logistics when we meet in person. So let's do that. And I do have another hearing scheduled at 11, so we do have an certain end date, end time for this, which will be 10:45. But I do appreciate everyone for joining us and making time to do this. I think we will definitely benefit when we get to the hearing to have some time to discuss things ahead of time. So I know it was late notice, but we do have many issues sort of hitting ahead in the last minutes of the time we have to prepare. So let's just get right into it. I do have a list of the pending requests that people have filed as motions, and the motion document type, we refer to them as requests for an ALJ order, but otherwise everything, all that should be pretty simple. So pending requests, I did want to mention something about Whitewater Solar's address, but we'll deal with that later. Offered evidence and corrections. I did send out a list, and I wanted to review that in case people had questions. And review some of the hearing process and preparation expectations before they hit as part of the schedule, and location logistics. If we have time, we can discuss the public session and the party's role in the public session. But let me mention this right now before, because it's at the end here, but I need to it'd be a good idea to cover it. I wanted to mention that I've been sending emails out to the service list, and the email for Wendy Schneider and the email for Lori Hoyt has bounced back recently. I think the message I've been getting is that they're out of space. Those emails are out of storage space. So I've called Wendy and asked her about it. She said she would clear up her email inbox so that she could receive messages. But so far the emails keep bouncing back. Lori Hoyt, her bounce backs just occurred recently with the latest flood of emails I sent you with many attachments. So I'm hoping that she can get that working again. But if people would like to take on the role of contacting them, I'm not going to have time to do that at this point. I just want to make this publicly known that I've been trying to get to these people by email. They're part of the service list, and I've just had those bounce backs occur. So hopefully they can get that resolved. So let's start back up at the top with our pending requests. Just trying to do maybe some of the more simpler, straightforward ones. First, the O'Brien, Mary, I believe she had requested more time to file surrebuttal, and the deadline that was requested was June 24th, I believe, and that time passed and didn't see anything filed. To the extent that I can figure out the filings in the case at this point, no one had responded to that request. So according to the facilitating matters order that's attached to the pre-hearing conference memo, that request is automatically granted. So I'm not sure if there was, and I haven't seen any surrebuttal filed by O'Brien at any time. So I'm not sure what happened there. Just wanted to mention that the request was granted by operation of law, but no filings were received. The commission staff had moved to substitute a witness, and again, there are no responses to that. So because of that, that request is also granted. we do have a number of motions then that kind of get more complicated, more deep into the woods. I think actually I want to just deal with another one that's I hope hopefully is simpler, which is at the end of my list here. There's a motion that can compel discovery from Clean Wisconsin by intervener LaSalle. Am I pronouncing that right, Yvette? Is it LaSalle, your last name?
Yes, Your Honor.
Okay, great. Just looks different right now. I don't know why. Okay. So looked like we had a full briefing on these, and I guess in terms of there was contention made that there was no meet and confer or opportunity to informally resolve the motion to compel. There's arguments that may or may not have been done. Looks like the reply of LaSalle to Clean Wisconsin had requested some specific information in order to perhaps negotiate the response, which was that the request was too burdensome. And I suppose I just was curious about the status of that, if perhaps Clean Wisconsin could enlighten us on if there's any consideration given to what was requested on the reply.
Sure, Your Honor.
Yeah.
So Ms. Lozelle emailed us on, I believe it was last Wednesday, proposing to send a reply the following day and then meet and confer on Friday. So I was willing to do that, but I wanted to see her specific concerns before I met with her, because I needed to consult with our expert about whether he could, provide any further answers to the request. And I didn't receive her reply until late Friday, so I haven't had an opportunity to do that. I did send him her specific request when I received it, but I haven't, since it was the weekend, we haven't had a chance to talk about it. We are willing to continue to negotiate with her about that particular question.
Okay. So
I will say though, can I just speak to that particular question?
Sure, yeah.
We believe that we fully answered her question, because it was, a question about what wildlife would benefit from improved habitat. And our witness responded that any wildlife that had access to the area would benefit from improved habitat. And Ms. Lozelle would like us to create a table to that effect, which we don't really see the point of. Although when I talk to our witness, he may be willing to do that. I don't know.
Yeah, I thought the original request was to understand the sources of the statement that that wildlife would benefit. Was, and maybe you can correct me, intervener LaSalle. I thought that was originally what was requested, that the sources be to substantiate the claim that wildlife will benefit with some sources. Wasn't that originally the
I am looking, Your Honor, I am looking for some substantiation, and I'm looking for some specific animals that the expert witness says are going to benefit. His answer is vague and it's not substantiated. And I'm asking for some specific species that he feels are going to benefit. And I do need that for the argument that I'm making. I do need that list. It doesn't need to be an exhaustive list. I even offered them a table. And as far as,
I understand where you're coming from, so I'm
I just want to
cut you off, but we don't have a lot of time. So,
thanks.
Interrogatory number 6 is what this is just a copy of the document that was provided on, I guess, the motion. So that's actually looking for a list, and Clean objected to burdensome. So I'm not subject to waiving. Okay.
We objected, Your Honor, to the original request which was that we create a new table to submit, and that seemed like a lot to ask at the point.
Mhm. Yeah, I suppose, I mean, the fact that it's a table, I don't know if that's throwing your expert off, but I think that the witness is looking for, or the intervener is looking for some backup substantial evidence about that claim, and I think that's fair. I mean, I don't know how quickly you can get this. So timing of discovery and after surrebuttal does run the risk of not being able to get in. Although we do have a lot of time in this case between surrebuttal and the hearing. I think if I'm gonna, so I think Clean Wisconsin is committed to, and I think that they should take best efforts to create a limited list of those species that are requested. But I guess that was in surrebuttal that this claim was made. Not sure if it had been made before, in previous testimony. To the extent that it may have been, I mean, this could have been asked before, but I don't know if it was or not. So that's neither here nor there. Just in terms of the process, yeah,
It was, Your Honor. It was indirect.
It was indirect. Okay. Right.
But
So,
we also have, just to further complicate things, we've got another response to her second set of interrogatories, which I will be sending her today, and that may answer the question, but we'll talk about it. I'll be in touch with her and we can talk directly about whether that satisfies what she's looking for.
okay, so it's another set of discovery. Okay, yeah, so just do your best on that. I think so this is something we're gonna have to touch on in some of the other requests, which is if there is not enough evidence being provided to the satisfaction of the interveners or anyone really, that's an argument that could be made for or against the project. I think that's a valid argument, and if the fact that information hadn't been provided, to the extent that I don't think it means you're indicting the person you've requested for lack of providing the documentation. We provide a process which is fairly complicated, and I mean, having assistance of an attorney would certainly have helped get this information and get it quicker. But for the interveners who have chosen not to be represented, that was another risk that was taken in terms of the process here. But as a default, sort of the backstop here is that to say there is not enough evidence here because I did not get a list of species that are benefit from the project. To the extent we assume that doesn't come in the record, that's an argument that the intervener could make to the commission. So ultimately, what we need to do is the commission needs to find that there's substantial evidence to meet all the criteria in the statutory review of the application. And if there's not enough evidence in one person's opinion that those criteria have been met, that's something that can be argued by that person. So I understand that, and we're getting down to the wire, but I understand that there may be some open-ended questions here in this case. And that, again, is a rationale, an argument that can be used to persuade the commission to respond negatively to the application in one way or another. So let's move on then. Hopefully we can get that information, but I understand Clean Wisconsin's position on that. So there's been a number of, and then there was also, so in one of LaSalle's filings, I think there was mentioned a pending discovery request from the Tillets as well, and I haven't seen any motions or requests to consider that, but I just wanted to see if we could handle that if we need to. I don't know if you have anything you wanted to present Ann Tillett about that, or Wade.
So I think that the initial questions that I asked, I never saw a response to any of those. And so I'm not sure at this point what I should do about that.
And who did you pose those questions to? The applicant or a different intervener?
I think it was a different intervener, but I would have to look back at the posting, sorry.
Okay. All right. Well, I think at this point, since you haven't made a request for, you know, if you haven't reached out to the party to seek response, and if you haven't asked me for help with that at this point, we're getting this close to the hearing. Again, I think you can make the argument that you need information you didn't receive, but in terms of the process of getting that information, I don't know if I can assist you at this point. And I guess I'd be surprised to see that, you know, a party didn't respond at all.
Is there an opportunity to ask questions during the trial or the
Okay.
hearing on Wednesday?
Well, that's a good question, and I think we need to review a little bit about that, and it may also touch on some of the other motions here. So, especially I think LaSalle had some questions about asking for additional time to file documentation, and that's, I think, listed here as number 4 on the list, on the screen share. And also, you know, I think in general, there's been 3 motions to dismiss the case. And I think that's on, and then and then LaSalle's motion to extend time. So I think we need to just step back and understand the process a bit. Yes, and just to answer your question directly, and there will be opportunity to ask questions at the hearing. So each witness will appear. Well, each party will be at the hearing, and they will sponsor each witness that that has filed written testimony in the case. So each witness, generally speaking, there may be some, we may be able to excuse a witness that no one has questions for. That's part of the process, but if there are questions for a witness, that witness will take the stand and those questions can be asked. So that's one part of the process that is designed to eliminate sort of this frenzy at the end, and people feeling that they're not going to be able to present their case. So there will be that opportunity, and we call that cross-examination, those questions of witnesses. Now, there's certain rules about cross-examination that, you know, again, if you had an attorney, this is like bread and butter attorney work, but for someone who's not represented, it's totally new. And I understand that we will definitely give people some leeway with how this process unfolds at the hearing, but generally we're asking that these questions would be, one type of cross-examination question is to get more information on a witness's credentials and their credibility. So if there's information with respect to their credibility that can be presented through those questions, and so the commission knows there's something, that may be there may be some reason to question the credibility of a witness. That's something that's a bit appropriate for cross-examination. And if there's questions, information you need clarified from a witness, that's an opportunity to have them on the stand and have them answer those questions. Now, again, if that question can't be answered, that's again an argument for you or the intervener person asking that question to say, I didn't get an answer to this question, therefore this project, there's not enough basis to approve this project. So that's one avenue that can be taken. So we don't need to don't need to fight about getting an answer. If there is no answer, that's again a point of fact for you to have in the case. So Cross is going to be limited. Well, there's a statutory limitation to reasonable cross. And I view that as meaning seeking clarification of what's been presented and seeking to, given the witness's expertise, asking them, why they didn't do a particular thing that would have been common for that person to look into. That's another kind of question that we see on legitimate cross-examination questions. So sort of errors, clarifications, errors, or omissions from the written filings. That's kind of the ecosystem of cross. And you'll probably hear objections to questions. That the biggest one, I think, especially for people practicing without an attorney, is just that the question wasn't clear. So you'll see an objection, and then the witness won't answer the question. If they've been instructed correctly, witness won't answer until I rule on an objection. So if you hear an objection, things stop basically, and then we hear from the sides, the questioner and the person representing the party being questioned. We'll hear arguments on both sides about whether this objection is valid or not. And I'll either sustain the objection, which means we move on, the question doesn't have to be answered by the witness, or I'll overrule the objection, which means the witness needs to answer. So those are the kind of the nuts and bolts of the cross-examination process. But even better, backing up a little bit more, when a witness takes the stand, we also provide an opportunity for the witness to add to their testimony. The parameters of that is that they can speak about what was filed last in the case. So in this case, it's the surrebuttal, and it's also the supplemental testimony of the applicant, the revised application. So in this case, what's available for this final statement on the stand of a witness is a little bit broader than usual, because it's not simply the surrebuttal. Another thing that people can comment on is what was said at the hearing. So typically the applicant will go first, and their witnesses will take all their witnesses first. Then interveners will go, and then commission staff will take the stand, and their witnesses will speak. So each witness can speak about any witness they've heard speak before them. So sort of you get that chance to reflect on what's now being presented in the record, whether it's the surrebuttal, the supplemental from the applicant, or what someone said at the hearing. So I'm hoping that will suffice to present a record in this case where, well, I'm hoping to give, that's our typical process, and using this process, I think, will provide everyone the opportunity to handle and present what they want to speak on when it comes to the supplemental and revised application. Now, I realize people are feeling swamped, and I certainly personally understand that. That there's a lot of new information, and there is little time to process. But again, there is that opportunity to argue if you don't feel like there's enough basis to approve especially the supplemental revised application. That's an argument that people can make, that there's not enough. There hasn't been enough time. There hasn't been enough process. There hasn't been enough evidence presented. Commission, like if you don't know, commission can either approve the application, approve the application with modifications, or deny the application. So those are the three options the commission has. Now, just to respond directly to the motions to dismiss on this matter. So I understand people's positions when it comes to the supplemental application, and that they feel overwhelmed by the changes, and that So I did provide, I think it's been the first time I've done this, unique to my practice, is to order the applicant to address those changes with the public and with interveners in my order to on my order for the request to leave to file supplemental evidence and a substitute witness. So that created the process for the open house and for the roundtable discussion. The open house is supposed to be with members of the public, and the roundtable with the parties. And I've seen a number of filings came in today, I believe, from Yvette criticizing that process, and I understand it was not going to be a smooth and uncontested process. That was just, but the opportunity I think we needed to provide, I needed to intervene and provide the opportunity for people to get a better understanding of the application amendments. If that wasn't enough, again, that's something you can argue. Didn't get enough information, process was incomplete. Commission should deny the project. But in terms of moving the motions to dismiss, I am not in a position or have authority to dismiss the case. That's something the commission, well, I think commission would handle that in the three options that we're presenting them, which is approve, modify, or deny. So the process will move forward, and what the commission does with the information we have, or the lack thereof, will be seen when the commission reviews the record and makes a decision. I did want to mention, though, just to clarify so I think I've handled the motions to dismiss just kind of in that response, and don't know if we have enough time to really go into all the details of every one, but I think it touches on the concept is the process is not perfect, but we're trying to give you the opportunity to understand the case and to provide your take on it. And we've gone to some unusual measures to try to provide that here, especially given the situation with the late changes made to the application. But that's in order that we proceed as scheduled, and we handle the case this way. And I have to say that I don't have the ability in my schedule to delay the hearing. It's already been noticed to the public, and I'm not inclined to cancel the hearing and move the date. But again, if the commission wants more information, they can order we proceed with another hearing, or they can deny the application and have it be refiled potentially, if that's what the applicant chose to do, and try again with a new process. So, but in terms of dismissing the case, I'm not empowered to dismiss a case. That's something the commission will do through its review of the record. I wanted to mention, I think it's because LaSalle had some comments about the public comment period, and I don't think I know the issue. I don't know if we'll be able to get all the details. I'm not sure which filing it came in on, but I just wanted to mention, so we did have the comment period for the EA for the environmental assessment, and that comment period ended, and then a new comment period opened where we were taking public comments in lieu of testimony at the public hearing. So those are two separate types of comments. So let me explain. The EA comments are used by staff to when it's the preliminary comments are used to develop the EA. And those comments do not appear before the commission. And we try not to have the two comment periods overlap. So we wait for the EA comment period end, and then we open the public comments for the record. Now, the public comments for the record are the ones commissioners will read. At this point, we have a new comment period, which is the supplemental EA comment period. I believe those overlap. And what I do then is so that there's no confusion between what people are filing and who's going to see it. any comment filed within the hearing, the public comments for the hearing, period, will go before the commission, whether they are intended to be made to the commission or they're intended to be made to supplement to the supplemental EA process. Because it was received during the period of time that I set in the notice of hearing, for those comments to go to the commission, they're going to go to the commission either way. Or both types will go to the commission if they're filed in that time frame. This way, people don't have to worry about missing a period of time in order to talk to the commission, and they don't get confused by an overlapping comment period. So the first ones that came in and then the period ended, those were EA comments and used by staff. The second period we have that are for public comments for the record, those are the comments that commissioners will see, and they may include supplemental EA comments, but that's just because the overlap couldn't be avoided. So I hope that clears up any confusion about the comment periods, but it's important that and then the important point is that parties who file comments, those comments do not go before the commission. So if you file the EA comment, that's not automatically going to be that. Well, none of those go before the commission. If you file a supplemental EA comment during the period where we're taking comments for the record, I'm going to keep those comments out because parties are not supposed to file a public comment. Now, you can offer that comment as an exhibit. It's a way to put that comment in, but it actually has to be offered for the record and go through the party hearing process. So you offer it, people can see it, they can object, they can ask questions. It just doesn't automatically get put in like other people, like members of the public comments do. And I know I've seen interveners doing that. So I think that process has been utilized by interveners. So any questions about all of that?
Your Honor, it's Intervenor LaSalle. First, I wanted to say I was very grateful that you offered the roundtable and the open house. I wasn't criticizing that you did it. My concerns was that I wanted to bring to your attention that I didn't think it was effectively done. And I thought that Your Honor would want to know that based on the order that you gave. The postcard that went out did not mention that there was any changes to the project. So my concern is that they've said that they complied. However, I mean, the evidence shows that they didn't comply.
Yes.
We didn't have enough time at the intervener meeting. We asked for more time. We didn't get it. So I was just bringing that to your attention because when I read the order, it said that you were only granting the supplemental stuff if they follow the order. And so I just wanted you to know that from my perspective, at least, that the intent of what you were looking for hadn't really been done. Anecdotally, many people in the area didn't receive the cards until the day before.
Yes, I understand your position on that, but like I mentioned, that I think at this point the commission's going to have to review that and see whether the process was complete or not, based on whether it, so the criteria it's going to need to evaluate is did it conduct the WEPA process under PSC 4 correctly, and is the application complete? It's going to have to take all of that evidence and decide. So that's. But I at this point I can't fix problems that that in your opinion you see.
I just wanted you to know.
Wait, you can't wait, ma'am, you can't talk at the same time.
Yeah. So let's leave it at that. I think, I do appreciate you bringing that to my attention, but I think that, if it goes, to the extent I see that you've filed a number of exhibits on that topic, the commission can review it so they can decide whether there is enough process or not. So I do. So did you want to say anything, Attorney Cahill, or?
Yes, Your Honor.
Okay, go ahead.
I would be remiss. As you noted, the process ordered with the intervener roundtable and the public meeting were unprecedented, and the order required those actions in a remarkably short time. From my view, Whitewater Solar made heroic efforts to comply. Email went out immediately to interveners advising of the roundtable with them. There was, I think, pretty much everybody on this call attended either in person or virtually. The public meeting, we sent out more than 1,000 postcards to 1,000 addresses. Notice was published on the Whitewater Chamber of Commerce calendar page. There was also a notice provided in 2 of the weekly newspapers and circulars in the community. In addition to that, Mr. House, who's sort of ran those, he provided overview of the changes. He stayed late and discussed those changes, and he's been engaged in daily, sometimes in person or phone call meetings with interveners to explain things further.
Okay, thanks. Looks like the Tillets had their hands up. Let's take Ann first. Any comment you'd like to make?
I just had a question about the EA comment time period. With the revised application, will there be a new EA and a new EA comment time period?
Well, I believe that's already ongoing, right? So it's a supplemental EA. So under PSC chapter, let me back up. So under Wisconsin Administrative Code, chapter PSC 4, there is a process to supplement the EA. And I believe the commission is already engaged in that process. So let me see. It issued a letter. It's going to appear pretty small here. Issued a letter on June 6th that talks about the changes to the application and that there is a deadline for this round of scoping. So the scoping for the supplemental EA, those comments are due June 27th. So I believe it opened on the 6th, June 6th, and closes on the 27th. And as far as I can recall, the rule provides a 15-day comment period. That's in terms of the rules that we follow for the supplemental EA. So so that's already ongoing, and I think that's where we're seeing the overlap of comments. This is why I was mentioning that those comments, unless it's filed by a party, those comments will be presented to the commission just because it's overlapping with the hearing comment period. Does that?
Thank you. I do appreciate that. I didn't realize that letter was the supplemental EA. I thought there was another document forthcoming, so I didn't understand that. Thank you.
Right. This is the notification that the commission will be creating the supplemental EA. And then the supplemental EA will come out later once they're done drafting it, getting it out.
Okay, thank you.
Mm-hmm. Okay. And okay, so we took care of you. Okay, so let's move on. This is more of a kind of a, well, it's not a picky detail, it's important. On the service list, I think we have for Whitewater Solar, I think we still have Drew Velbig as the official contact for commission communications. We call that our utility primary address. And the people who need to change that is Whitewater Solar. Commission can't adjust that entry in our system. There's a link here that allows the person to log into their account and then change those identifying contacts in our system. So you'll see our primary address does show up on the service list, and it's still showing Drew Velbig, and it will continue to show that person and their address, email address on the service list, and that'll be the only. So we consider that the official official contact. So when we send out, for example, the commission order in the case, that's the one we need to send it to make it official. So if you could change that entry to the person that you, or maybe you still are able to, maybe that person's still able to take this this service here, but I think it needs to be updated from what I'm gathering about the status of
course,
the,
Your Honor.
yeah.
We'll make that change.
All right, and then I can change the service list once that happens. Okay, so again, O'Brien's not here, so not sure where that rebuttal was. We were expecting to see any, but we do have a number of documents in that correction list that I filed, sort of a preliminary list. So you will be getting more of a table-like document that'll show you all the parties and their position in order of when we will take their testimony and how their documents have been organized. So let me just quickly show you an example, maybe useful to see. So you'll be getting this version of this document soon. A second here. So this is a list in a recent case. Taking a lot longer to open. There we go. Okay. Yeah. So this is what similarly, well, your offered evidence list will look something like this. So it's going to provide a way for us to organize the party session, showing who the applicant is, all their witnesses, all their filings that have been offered for the record and that I intend to receive for the record. And it's got these correction comments. So the way we'll proceed with the hearing is that we'll have this list. We'll make sure the list is accurate in terms of errors or omissions. And we will expect and then I'll have my filing comments embedded in the document. And then you'll see we will have the witnesses verify these documents under oath. Then I can receive them pending the corrections that are due in 3 working days. So no weekends, no holidays, just counting working days. That time frame is not super important, so we can probably extend that out for people who are having trouble getting the changes made, but we can talk about, I've made it easier for a lot of the interveners. We'll talk about that in a second, but basically you'll see that so the applicant has its witnesses listed, then the interveners have themselves listed. We have a lot of landowner interveners in this case. So, and then the corrections are explained in the comments. So it's similar to what I've also provided. It's just, this is the format you'll see probably tomorrow. Just so you don't get scared about that. So, so in terms of the current list, I did want to, so the current list has a number of comments for a lot of people, but I did want to mention, what I've attempted to do is to reformat the testimony of many of the interveners so that you don't have to file corrections. Some of those corrections are also dealing with essentially striking some of the parts of the testimony that I feel has not been substantiated by documentary evidence or by the expertise or credentials of the witness. So that was to overcome both the motions to strike those documents and also my basic parameters that I use to in order to find that testimony and exhibits have enough probative value for the commission to use. So we've essentially, I've allowed testimony to come in over the objection of the applicant. However, there are some modifications that needed to be made for me to find that there's that there's a probative value for those documents. So I did want to ask about some of the documents that I believe I have not corrected. So I'm asking the interveners to do so. And it ended up being the Tillet exhibits. I just don't think I got to them, but I'm hoping you'll be able to refile those. Oh, and also there's some questions about that. So I'll probably go off the record for this, give the court reporter a break. So I guess the first thing, oh wait, let's just get on the record one more time. Sorry. This is important to understand. I saw a number of documents coming in now as exhibits today. And I think I try to make the process simpler as we get to the hearing. So there is a requirement that if you want to present a document at the hearing, you should share that with the parties and myself. But all you need to do is email it. So they really didn't need to be filed and probably shouldn't have been filed already. But I mean, it's already, a lot of them are already on Earth, so that's fine. But that was supposed to be a way to make it easier. And what we have here is the process, which you'll see coming up before the hearing, is that one day before the hearing, so July 1st, parties and staff should email each other and myself by 1:30 p.m. There's a couple of things we're expecting to see. If you needed to be called as a witness at a specific time, and now in this case, it's a specific time or day. It's either going to be Wednesday or Thursday. Let us know now so we can plan ahead. If you know who you want to ask questions, cross-examination questions to, let us know in that email. That's just a way to gauge the timing of the case, but it does not waive any right to cross-examine if you didn't put that person on the list. It's just a procedure, an administrative information for me to know which witnesses have a lot of questions coming to them. A lot of people are interested in. Identify any portion of the hearing that we may need to handle confidentially. And I don't think there's going to be much here in this case, but in case we needed to break out to a confidential session, that's good to know ahead of time. Request scheduling of additional hearing time. You can request it, but like I said, my schedule is not going to allow, as far as I can tell, additional time. We'll have to try to get through the case as much as, to the end in the 2 days we have. So let me actually warn you now, as we'll probably be going late, especially on that first day. On the second, we'll be in the hearing room, and I can provide like a dinner time break, but I'm expecting we'll be, unless we're moving along quickly, we'll have to be staying later on the second. We'll see how much time we may have to do the same on the third. So it's unfortunate, but the press of the many cases I have in my schedule, I just don't see where I'm going to fit in more time. And then the fifth thing is to provide those attachments, the documents that you want to bring up at the hearing. Now there's kind of a trick to this, which is that we really, those documents should be documents you're going to be using on cross-examination or documents using to support what you're saying and as part of the supplemental testimony that you can give at the hearing. And that's limited in some ways. And I know this case, it's a little bit broader than usual, but it is limited to, traditionally, it's limited to documents you didn't have before. For example, you know, things that you probably should have had presented on your direct, could have presented on your direct, but just didn't get offered on direct. We want to make sure that we're reducing the chance of surprise and prejudice to the other parties and commission staff, giving them, you know, problems with giving them enough time to review a document and vet it and be able to ask questions about it. I understand this case is very different in terms of the procedural timing. So I will give some leeway on that, and I guess we'll just kind of have to play that by ear. But it's good to have. But just so you know, like these documents can just be emailed. You don't need to format them and put them on earth. That's just a way to try to help things move faster for you. And that brings us to a couple of the exhibits that I've seen. So Ann Tillett, you did file your resume as Exhibit 4 on your testimony, and I didn't see. I guess that's nothing that I'm not sure if you had referred to that before in your testimony, but I'm assuming that's a document you wish to bring up at the hearing.
I've been working on some additional testimony that I was planning on submitting this afternoon. And
Okay.
so in that I referred to my resume, so I thought I should submit it as, you know, I had that done already on Friday, so I went ahead and submitted that. But that's why my comments haven't been submitted about it yet.
Okay. So like I mentioned, I mean, it would be, well, if you guess there's still an opportunity to file something if you wish. If this is something you could read into the record on the stand, I'll allow that. So you really don't need to be filing, but because it is close to the hearing, so I can let you decide that.
Your Honor, if I may, it appears that the interveners are using surrebuttal to introduce a host of exhibits and additional testimony that could have been on direct or rebuttal that is not limited to any response to the Whitewater Solar's rebuttal, supplemental direct, or surrebuttal. We're going far beyond the bounds of the sort of narrowing approach that is traditional in the commission. And while there may be efforts to excuse it by the change in the layout, I don't think most of it can be excused that way, and that much of this is too late and after the fact stuff that they wish would have been in their own direct testimony. And Ms. Tillett's resume is an example. I think Ms. LaSalle filed 60 exhibits this morning that fall into the same sort of category.
Okay. Yeah, go ahead.
Speaking of that,
Yeah. So we don't really need, so let me just say, first of all, we don't really need to debate this now in the abstract. But I think that's the two sides of the story I think we're seeing. And they both have legitimate arguments to them. I will have to see the documents and hear what's being offered as testimony to be able to decide whether the supplemental testimony and documents meet the standards that we have. And again, it's kind of traditional standards plus, because we want to say that there are, I mean, I guess basically what I'm saying is that it's not only the surrebuttal and what you hear at the hearing that you can comment on when you take the stand, it's also the supplemental evidence related to the change in the application. So we would need to judge that's the parameters by which we would need to judge the new evidence coming in. So keep that in mind when you're formulating your next round of presentation. Now there was let me check this. I did ask for yes, okay. So I did ask or instruct parties to interveners that in my order related to the supplemental evidence, I did instruct parties to file a rebuttal with respect to the proposed application by today at 1:30. But that also, that's an opportunity to do so. But there's also the opportunity to provide this at the hearing, speaking the testimony into the record and providing your, and tying them into your and tying the documents that you're providing on that day into that testimony. So I think it's an either or for parties to have that opportunity, but everything here will still be subject to arguments that it was really related and should have been presented on direct or rebuttal or surrebuttal rather than this kind of supplemental last round. So we'll have to vet what you're saying or what you're submitting with that lens, whether it's responding to the supplemental application or whether it's responding to the surrebuttal. This is something that we usually try, and this is going to probably take some time at the hearing, time out of for the hearing, but unfortunately, but I think let's at least set up the expectations here today. I don't think I'm going to be able to rule on those what we've seen filed already, and it's really not there's really been no request to rule on them at this point. So we'll have to see how this plays out at the hearing. And again, like I mentioned, that backstop that the interveners have is still that the record is not sufficient. It could be that the process does not allow you to present everything, but that you still have an argument that the record is incomplete because of the procedures or because of the substance. It's still available. That argument is still available to you and would align with the commission's need to make a decision in terms of approval, modification, or denying the application. Let's just go off the record for a second. Deanna has joined us. Okay. So I see Deanna, you've joined us. If you can unmute, turn on your camera, and just let me know who you're connected with. Could unmute, please. So I see. So is this Deanna Schrodel? Shroedl? Could let me know.
Yes.
Yes. Okay, great. So let me just so we have a new person connected to the hearing. Can you just state your name for the record, please?
You want to be on the record?
Yeah, we're on the record. Yeah, sorry.
Okay, go ahead. Say it again.
Diana Schroedl.
One more time. Sorry.
Diana Schroedl.
Great, thanks. Okay. All right, thanks for joining us. So let's move on with, and let's see, did someone else have their hand up about what we're talking about? No, I didn't see that. I thought I saw somebody. So yeah, that's probably going to end up taking some time at the hearing, but I think we need to, we'll address those when matter when it comes to us. So I do want to mention, so I did ask for the Tillets to refile, and I think we can do this off the record. Refile their exhibits. I think it's because I really couldn't figure out, or I'm going to have you figure out. We need to have a cover page for these exhibits. That in the cut. Let me just show you. So the cover page. Okay. Cover page is one thing. Cover page is just going to show you, show us all the name of the document. And I can find, okay, this one should probably work. So if you can see, I'm just going to display one that I hope has a correct cover page. Okay, that's not exactly not exactly right. Okay. Let's see. Did I file? Actually, I didn't catch that one before. Okay, here we go. So cover page on an exhibit is going to look like this. Just this is all I need. This is all I require. We have room for the stamp PSC puts on the documents, and it's got the marking the name of the exhibit at the bottom. So it's just typed in exactly as it should be. EX dot dash the party identifier, so it'd be Tillet dash, and then the witness name, so it'd be A dot Tillet, and then the name of the document, the number of the document would be -1. And then I'm asking you to add the R to this since, I guess, I don't know if I am. Yeah, I guess I am. Yeah, I'm asking you to add an R because it's refiled. So just a single R. So that would be the first part of the refile, is just to see the cover page. And then the issue with this is the appendix to another document. And it's really hard for me to find how these documents tie together with the documents we already have on file. But what I'd like to see is just have this first page just be the title page or the cover of the document that this is an appendix to. So I think it's the Walworth County Farmland Preservation Plan update would just be the first page of that would just be on top of this page. So we have the cover page, the title page, and then this part of the document. So that would really go a long way in making, especially the commission, understand where this is coming from, and so they can rely on it. And I think all of these documents are similar, where I just didn't want to assume where these things came from or what title page should be on there. So if you could do that work, and it would be officially due 3 working days after the last day of the hearing. So let me be clear. If we do end on the 3rd, then we would count after, starting on the 7th, 8th, 9th. So it'd be on the 9th at 7th, 8th, 9th. 9th at 1:30 p.m. is when they're due. But if you need more time, let me know. Just unofficially, it's not super critical that it gets in exactly on time. I don't want to freak people out, but those are the changes you'd need to make to the Tillet. And I have the comments. You'll see those on that table that I'm going to give you, but it just really just very detailed, explicitly tells you what to do. And then
Thank you.
okay, great. Thanks for the buy-in. Okay, so then I did have a question with Tillet 2. I'm sorry, Wade Tillet 2. I wasn't sure what I was looking at. And first of all, I was just wondering if it may already be in the record as a document that could be more, if you're taking a picture of a document that's on Earth, we don't need to refile it here this way. We can refer to it to the filing that exists. or we can find that page and make an exhibit out of this page. But this picture, I don't think I can let into the record just because of unless tell me what it is. But I think just the way it's framed up, it doesn't seem like something where I can accept. But let me know what's going on here first. So you want to chime in there, Wade?
Yes. That is a screenshot of what Drew showed us when he came to our house in August of last year, which is different from what is on Earth, which was my point.
Okay.
Is that it is different. And that was the reason I included the screenshot, was to show that what we were told is different from what was on Earth.
Okay. All right, we'll have to review your and just, we're off the record, but just so you know, so this was this taken with Drew when you guys were talking? Yeah, okay.
And this was before the application was filed.
Well, it's got the date right on there. If hopefully that's the correct one, August 28th. Do you remember?
Yes.
What year? And what year was that?
That was 2024.
2024. Okay. Okay. Well, any thoughts, Attorney Cahill?
I don't see that this exhibit adds anything, because it corresponds to, for example, PSE document number 521001. At page 4, the layouts correspond.
Okay.
Now, the initial application, of course, did change, and so the revised application does show a revised layout. So yes, as between the initial application and the revised application, the layouts are different between each other, although what is, I guess, Mr. Tillett's Exhibit 2 appears to correspond to what is shown in the initial application exhibit.
Okay. Give me that PSC number one more time, please.
521001.
Just and you had a page number as well.
Page 4.
So that's the PDF page.
Correct.
So I think, well, I'm seeing. No, I'm seeing the same thing. So it's 521001. It's the PSC number. Okay, and this is
it's figure 4.1.7.2, the detailed land ownership portion of Exhibit A.
Yeah.
To the application. Yep.
Yeah. And PDF page 4 puts me on page 31.
Correct. Yes. And Mr. Willett's and Miss Willett's property is sort of on the bottom left corner. There you go.
Okay. And okay, so the difference between the pink and the green maybe is part of.
I mean, to me, it appears the difference is coloring, but in terms of panel location, they correspond as compared to laydown yards. Those seem to correspond.
Okay. Okay, so I'm just gonna it might not look very good, but I'm gonna try to just show it both and see. I mean, I would rather put the document in that's already on Earth rather than the picture of the computer, but if these are representing the same things, then I would be inclined to have basically your testimonial just cite to the document that's on file rather than the picture. they're showing the same thing. So, I guess what's missing is the arrays themselves, which I don't know if
The pink shows the arrays. I mean, it doesn't have the lines.
Right,
of
the
course,
lines
but
is what I'm talking about. Yeah.
I mean, I think what matters, and we would not dispute, right, is yes, the layout change between the initial application and the revised application, including in the area around the Tillot's property.
Yeah. Okay.
And that should be easy enough to make that point with the existing application exhibits.
Right. Okay. Yeah, I think that's so Wade, that's where I would head, is just to have your testimony will just cite to the application document rather than the picture.
Okay. Thank you.
Okay. All right. Gotta we clear that up. Okay. So, and I think in terms of, that leads me to just wanted to review how much time. Well, we don't have a lot of time. All right. So you'll see on the list that I provided you with the changes and comments, that there are a number of documents where I'm just refiling, changing some of the formatting, refiling for the intervener. And so I wanted you to be aware of that. Probably don't have enough time to review that specifically. Did want to mention, okay, we have Kronwelter back on.
Yeah, my apologies. I accidentally hit the wrong button and ended my call.
Okay, hope you didn't miss much. Okay, so I do want to mention, so with wood, I had actually unfortunately did not. These have been some late nights trying to do this.
You're still off the record. You're still off.
Off the record.
Okay.
We're off. I didn't actually use. I think I may have cut and pasted the wrong document into the version of Wood that I provided you in my email. So I do have a new version that I actually used the Wood testimony to reformat, but it was just changing the the look of it. So yeah, now it does have what Wood is saying instead of, I think it was Wagner, repeating Wagner's testimony. So sorry about that. I hope I didn't scare anybody by doing that. The other one that I haven't shown before is the cell surrebuttal. As I did mention, there would be essentially there's a portion, a rather bigger portion that is basically legal argument, and that's something that is totally appropriate in a brief and in the briefing that occurs after the hearing. But I think in terms of the record, keeping the record coherent and hopefully streamlining the process a bit, we can basically, my plan is to take out the legal argument from the surrebuttal and have the witness can certainly totally free to put that into the brief. But if all you're doing is taking already offered evidence into an argument and then applying it to the law as you understand it, that is appropriate for the brief, but really we don't need to have that in testimony. So it's basically this, the project as a merchant power plant issue would drop out of surrebuttal, and you can just put that right into your brief, essentially the way it's stated. It doesn't have to be question and answer, but I think the answer is a valid answer to brief on. So all of this could just go into your brief, and and other parties in the commission, other parties can respond to that as a legal argument rather than trying to bring in, trying to argue the law through witnesses. It's not really how we operate. So the one point I think was made dealt with the witness house's statements. That's obviously not a legal argument, and that would be fine to be presented in testimony. So that's how the surrebuttal though, Yvette, that's how your surrebuttal will appear. Just to take out what's legal argument, and you can put that in the brief.
Thank you, Your Honor.
Okay. Then I did mention it's been quite a while that I had this comment made. I think I sent an email to parties about direct testimony. And so that's actually going to reflect changes in terms of the citations that we can't rely. I can't have the commission rely on citations of things like Facebook or podcasts that there's no, well, there may have been an author to that podcast, but I think I can't get a podcast into the record. So that testimony has been extracted as well. I think there was a number of citations from intervener LaSalle on direct. But like I said, I need to balance out allowing testimony over an objection, but still keeping parameters that I'm comfortable with for probative value. So that'll be reflected in those changes too. So we reviewed, so let me mention, so it's probably getting too late. Well, we already had the errata testimony deadline pass. I did want to show you what this looks like. I don't think I really got any, can't remember if the applicant submitted any, but the errata is really trying to identify corrections to testimony in a very simple way. You just tell me what your testimony is and what changes you wanted to make, replace one word for another, and then so if you have more corrections, we can this is the appropriate way to request a correction to your written testimony. At this point, it's kind of too late, but if there's something that's very important, a mistake that needs to be changed for substantive reasons, I can hear that at the hearing before you probably at the beginning of the hearing. But just so you know, it's frowned upon. This is the appropriate way to request a correction to your testimony, in the way that we can give everyone a heads up about it. And hopefully we won't have to deal with it. So when it comes to transcripts, you do have an opportunity to, when the transcript comes in after the party session, you will have an opportunity to request corrections to the transcript. So it's the same idea as to file this errata that deals with the transcript, changing words that may have been misheard, or maybe there was a spelling error. There's some, so those are fairly tight parameters. So we don't really want people changing what they said. There may be some leeway if everyone can agree that a change needs to be made for the sanctity of the record, for accuracy, but that's a high bar, and we don't want people we don't want the transcript to change and then cause prejudice to some other side, that all of a sudden the facts change in a substantial way that they don't agree was just a mistake that needs to be changed. So we don't want to cause more arguments with the transcript corrections. And you won't see like an order on this. I'm just going to collect them all. I can collect objections to the transcript corrections, and then I just tell the court reporter what corrections to make and what not to make. This is sort of a courtesy more than anything, but we want to make the transcript as correct as possible, but also not overstep the bounds in that process. So you'll see that's in the schedule, the process for requesting corrections and objections to corrections to the transcript. But this is what basically look the same way. You just want to show us what those changes are. Okay, so hearing logistics, probably the most important thing. We have about 15 minutes to go. So we are conducting the hearing in person. Well, we're always in person, but we'll be on location at the commission It's at the Hill Farm State Office Building, and it is in the hearing room, the PSC hearing room, which is room number S105. And I can see if I can, this link will work. So there is some information on our website about some of the details of, yeah, okay, so the address, I guess, is on, oh, there you go. So on the commission calendar, I don't know if you've been using this, but we have the online calendar, does give you a map of where to go. And zoom into that, it may be useful. So importantly, there's a Whole Foods next door. We go late. I don't know how late they're open, but we used to not have anything nearby. So
They're open till 8.
there you go. Okay. So here's our, so yeah, so you'll see it as a DOT buildings. DOT building, here's your parking. And our hearing room, the door is over here. So you need to, there'll be parking here, and you want to go around and come around the corner. This is the employee entrance. You can come through there, but then you may get lost. And when we, after hours, after 5:30, the door is locked going into this, the employee entrance. Capitol Police should have this door open until we close the hearing. So we'll be able, you guys be able to go in and out of the building. Parking is, the lower level is, no, the first floor is visitor parking, right? And then the 7th floor is visitor parking. So having hearings here can be a little tricky because there's parking and there's all kinds of stuff getting to Madison, etc. So, you know, we meet those challenges. We're going to start at 10 on Wednesday. We'll probably start at 9 on Thursday. So you will need to plan ahead for that. And I just want to get back to this page. So we do have some rules about visitors. That's on our web page. There's this visitor page. Shows you a little bit of the building, but you don't need an appointment. But we do want you to check in with security desk, which is when you come into the front door that I showed you at the where the hearing room is. Security desk is on your right. So I think you just need to check in and give you your name. You don't need a badge because you'll be on the first floor. That's what the desk actually looks like. And I think parking is here too. So there is parking is paid parking. So here's the rates. I would expect going to be there for 6 or more hours. And just so you know, there's a gate that goes down. If it's after hours, the gate will be closed. When you exit, you just need to proceed through the gate. It'll open up if all goes well and let you out. We also have, so I keep failing to get a picture of the room for you. I apologize. You can actually see, if you look at the last hearing that we did, which is 9827 CE 100. We did 2 days in the hearing room, so you can use our YouTube channel to review what the room looks like, get a sense of how it works. But basically, we have like a judge, a bench. So I sit there, looks like a real courtroom. Then the well in front of me has 5 tables. We can fit 10 people comfortably around the table. And so I think that may be all we need for the people who are, you know, actively participating as parties in the case. So everyone should get a seat at the table. There's going to be microphones for everyone. And we'll also have these devices we call owls, which look like fancy, I don't know, pencil points, I guess, that stand on tripods. That's for our Zoom connection. That's the speakers and well, it's the microphone and camera for Zoom. Does a pretty good job picking everybody up in terms of audio, and it actually zooms in on your face if you're speaking. So the system's working well. It does a pretty good job. So people will be seeing the live stream through the Zoom. People can connect through Zoom. I do ask, you know, if you are I'm expecting people to be at the hearing unless they have some sort of problem, especially, the intervener landowners. I think it's beneficial that you show up and be at the hearing. Although I don't believe I required that. I think it's, you probably want to be there. So if we have break time or, like I said, we may have a dinner break. There is a break room for everyone who wants to use it. I was able to secure our biggest room on the first floor. It's N108. You have to find signs, try to put up signs directing you to that. But basically, it's on the other side of the building. We'll have to point you to it. It's a really big room, so I think everyone can find a spot to congregate there on breaks, or if you're not a witness at the time, you can hang out there. We are not able to provide. There's large displays, but we're not going to be able to display the hearing on the screens. But there'll be the live stream, so you can use your phone or your laptop or whatever you have to keep track of the hearing while it's going. That's the spillover room. Microphones. Just wanted to mention, you'll see that there's a button you push to speak. You want to make sure the green light is on. However, the Zoom camera and microphone will be on all the time. So if you're trying to whisper something, not be heard, even if your microphone's off, you may be heard on the Zoom. So just a warning there. I do mute it and turn off the camera when we're on break. So you'll actually see the owl device actually lights up red when it's not operating. So, or I think when it's muted, it's red. We have a T-coil system for people who have hearing disability. That's available. So I believe it will work with a compatible hearing aid, and also we have a in-ear device you can use that connects to the room audio. So plan to run to the evening, like I mentioned, especially on the first day. Try not to go late on the second day, because I know there's a holiday, but so for that reason, we'll suffer on the second more, hopefully, than on the third.
Excuse me, Judge Newmark. When you say go late, I have a farm and so do some of the others. Could you give us those times, sir, like about how late you think it could be? I'm sorry to interrupt.
No, that's fine. Yeah, I mean, we need to get this done. So, I can't really give you a specific time. I mean, if things are going well, and basically,
I mean, are we talking like 8 o'clock? Are we talking 7?
I'm gonna say, so that you can prepare, I would say we could go as late as 9.
Holy crap. Okay,
Yeah.
thank you.
So it depends on how long how long we take, because I think this is why we need to kind of keep the concepts of the hearing and the record and the process in mind, in the sense that interveners have been able to present their evidence in their written testimony, and we'll provide that opportunity to supplement and to ask questions. But to the extent you made your case in your written documentation, there may not be a lot to do. You know what I mean? So if you said what you wanted to say or need to say it's already been in the record, there may not be a whole lot. Now I know with the supplemental application, there may be some, inclination to try or have the need to add more and talk about this more. Now, but I think that has to be gauged with, what the changes actually are and how it affects whether your testimony that you've already presented really needs to change or not. So we try to streamline the process so we don't have to, take a lot of time at the hearing by having that written format, and then to have the in-person, the live hearing be more of a check, make sure we have all the documentation we need, and the opportunity for cross. And I understand this case may be a little different, and so that's why I'm saying plan ahead. for an extended stay on the 2nd. And because this case may be a little different, we may see or hear a lot more being done at the hearing. So that may be the best way we can handle it. This way we're not going as late on Thursday. I think we can all agree that's probably better than Wednesday. So I would say, if we decide to go that late, I'll provide a dinner break, like a more substantial break. So maybe like an hour for dinner, so we can hit the ground refreshed, maybe 45 minutes. We'll hit the ground refreshed and work on the next portion of the case. But yeah, once we get everyone here, we have everyone logged in, we have everyone sitting there, it may be more efficient just to get more done on that first day, and then use the second day as hopefully we won't have as much to do. So yeah, I would just be safe, let's say 9, and then everyone can plan ahead. So yeah, thanks for asking that question. So we had Kara, did you have your hand raised?
Kara.
Sorry.
That's okay. So I just had a question about witnesses appearing via Zoom. It sounds like your preference is to have everyone come in person. I'd had some questions from a couple of DNR witnesses.
Yeah, well, I mean, witnesses are allowed to appear by Zoom.
Okay.
I think my caution on that is for interveners, especially because they are witnesses too, as well as the representative of their interests. Usually we make attorneys come to the location hearing. So I just think, interveners who just want to verify their testimony and don't have a lot more to add, that option of being present on Zoom may be, in their interest. People who want to ask a lot of questions or want to present something more substantial, and when it's their turn, may feel like they need to be there. So, it's not a requirement, but since we're doing this in person, we're doing this on location for a reason, and that's to facilitate, especially the participation of the non-represented landowners. So I would what I'm saying is take that opportunity, if you can. So yeah, so in that sense, yeah, I guess, you may run the risk of, say, for instance, the connection not working, or you may run the risk of not being able to hear someone, or you may run the risk of not being as connected mentally to the hearing as you would if you were in the room, because other people are in the room. So I do a pretty good job not to overlook people who are on Zoom, but I guess there's a chance of that. There's a lot going on at the hearing. So let me leave it at that because we do need to move on. Becky, did you have your hand raised?
I did, thank you. So just gonna let you know right now, having Jared present till for a 12-hour day, I expected business hours. So a 48-hour notice to go till 9 p.m. is probably not going to be accommodated by him. So the option does exist for Zoom is what I do hear, that can happen. And then you recommend that we just stay live in Zoom for the entire time, and then when needed, I could drag him into the room and, or off the farm or whatever the heck he's doing, and have him speak his piece? Or how would that be facilitated?
Yeah, so I guess if you could clarify your role, I didn't realize you were going to be continuing to represent him. Is that
it's not really
you're just here to stand in for today?
Yeah, no, I was kind of standing in for today, but I'm going to bring whatever the process he needs for the next couple of days. I guess I wanted to clarify that for him. So
yeah,
I guess, and maybe that's difficult to interpret or understand at this point.
Well, I think he's going to have, I mean, from what I said before, I think if you could convey that to him, or he can watch the YouTube, that, he does have an opportunity to respond to what he's heard at the hearing. So if you're not there, you may run the risk of, missing that, but that's, and maybe that's not critical to what
okay, that's fine. An element
to do. So yeah, if you want to monitor the hearing and be able to call him when it's his turn, that's fine. So And let me say, so we did have that offered evidence list up on the screen. So before, and so that gives you a gauge as to where you'll be called, when you'll be called, depending on the flow of the case. So it's applicants first, and then the interveners in alphabetical order by party designation. So I think it's last names for the intervener, non-represented interveners. So you can say, well, if I'm going to be going after Yvette, so now I should be on deck. So that would be something you'd want to see.
That's fine.
That person ready to go. Yeah.
And then
otherwise, I can take people out of time. Then again, they still run the risk of not hearing what was done before. But that you want to email us by the 1st to be taken at a specific time, or if there's a specific time you can't be called, let me know that in the email. So that's another, that kind of smooths over some of the maybe what people having concerns about. But if you want to be here and be present and participate, then you're going to be staying. I'm expecting you'll be staying late on Wednesdays.
Yeah, I mean, I think he does want to be there. I think it's just hard to suddenly do that, especially with kids, family life. So final question, are people that are non-interveners or outside parties like myself allowed to attend in person?
Oh, yes, there's a lot to still cover here. I gotta go quickly, but
muting.
So yes, it's an open hearing. It's a public hearing for, well, let me say it's for the parties, the party hearing session. It's open. The meeting is open to the public. So the doors should be unlocked. We may have to close the hearing room doors because it's very loud in that hallway. So we'll have a sign up saying come in. But yeah, so what's available for the public is the live stream and being in the room. We only want parties connected to Zoom for that day. For the public session, we want to make sure that parties understand that they're not participating at the public session. If you've given your testimony here, you've precluded yourself from testifying as a member of the public. What we do allow is that parties can encourage people on their side to make a comment, either through the website or by mail or by attending the public hearing. But they can't be filing comments for people. They can't be participating for members of the public. So to the extent you want to say, hey, there's a hearing, you should come, that's great. I would encourage, well, we do ask, and it's part of the requirements that you refer people to the notice of hearing so they have all the details, they can see the facts, how to participate themselves. And I guess part of the problem is if a party gets in the way of the public making a comment, you may end up maybe to those people's detriment, because if I can't accept their comment, they've lost the opportunity to comment. So don't get too involved, but you can advertise, you can encourage people to attend, you can encourage people to file a comment. But in terms of like gathering comments, gathering petitions, things like that people like to do, that's not the role of a party. Parties need to be kind of separated from the public session, the public process. So any final comments before I need to get to my next hearing? So see, Yvette's got a hand up. That from before.
Yeah, I just had a question, Your Honor. Is it possible, because we have that discovery that's going to be coming in, Mr. Tillett and I both have discovery that people have committed to bringing in today, could we at least have until the end of business to submit our supplemental testimony? My argument for that is that it will help streamline the hearing if we're able to get those things into the supplemental testimony and handled.
Okay, so you want to the end of the day to file supplemental?
Correct, at least.
Okay.
Yeah, it'd be great if we could have till 7 a.m. tomorrow, but by the end of business today or midnight tonight, I mean, anything so that we could just, because they already said that they're going to give it to us, and we could just wrap those loose ends up so we're not dragging it into the hearing, you know?
Yeah, if it works out that way, that's fine. So we can have you submit. I mean, I can do it. Let's give you until what did you say, 7:30 today?
Well, I mean, if we could have whatever works for you, Your Honor. I mean, if you want it in by midnight tonight, if you want it in by, I mean, that would work for me.
I mean,
Your
do
Honor,
you have a commitment to the timing of getting
Your-
that information in?
I'm not clear what's being filed since the rebuttal's already been filed by Ms. LaSalle.
Right, there is an opportunity to file a supplemental based on the application changes. That's due today.
Limited to the changes.
Correct.
And yeah, well, the order says, let's just get that up. I think it has to do with the information that was provided at the roundtable as well, and the open. So it's this number 3 in the order on the supplemental evidence. Interveners may file supplemental rebuttal with respect to the proposed application revisions anytime after the roundtable meeting, but not later than 1:30 on June 30th. So so I'm not sure if this is related to the supplemental, but I can give you till 7:30, and then if it solves the problem, that's fine. So let's shoot for that. I'm not sure if that discovery is going to be in by then, but
It's due by 1:30, so that would at least give me a couple hours with it. I thank you, Your Honor.
okay, that's fine. All right, so thanks very much. I need to leave for the next hearing, so I appreciate everyone joining us. Certainly, you know, it'll certainly be helpful. I'm glad I could present some of this information to you. But we need to go now. So thanks very much, everyone. So let's just get on the record and adjourn the status conference. So thanks very much. We're adjourned. I'll see you on Wednesday.
Thank you, Your Honor.
Bye-bye.
Thank you.
Thank you.
Thank you.
Thank you.
Hey there, I see Matthew Gillis has joined us. This is Mike Newmark with the Public Service Commission. Let me know if you can hear me.
I can. Sorry there. Can you hear me now?
Yep, great. So just in the middle of another hearing, are you here for the water case?
I am. I'm the Public Works Director here for the City of Durand. The City Administrator will be joining me on this device too. We're sitting in the council chambers. We got it up on our big screen for anybody, a member of the public that wants to join. This will be the city public comment portal, I guess, if you want to call it that.
Okay, great. Yeah, excellent. Okay, well, sit tight. We'll be starting at 11. I got to get reoriented from the last hearing. But you'll see some new stuff appearing on the screen, and I'll get our live stream up and running for this case. So good. Just sit tight and we'll wait for other people to join us.
Sounds good.